hey guys, if you stop somebody for a very minor traffic violation and you write them a ticket for that, but you stop somebody else for the same violation and you don't write them a ticket, do you have a problem in court? I'm going to explain what I mean here, but the first thing is my name is Anthony Bandiero, and I'm joined with my good friend Zach Miller, and legal instructor for Blue to Gold. How you doing, Zach?
I'm doing well. I'm doing well.
All right, that intro is a little convoluted, but let me just kind of share a little backstory so we can see how we can answer this. This officer is in Ohio. He says, first of all, he does thank us for all the hard work that we're doing for these cops to train them, and whether it's in classroom, on YouTube, Instagram, and so forth. He says, say an officer makes a traffic stop for a de minimis violation. Now, de minimis is Latin for minimal. That makes kind of sense. I can understand that. And it's very minor, let's say chicken shit is really, I think, is what they call it in court.
Right.
Here's, for example, 2 miles per hour over speed limit or one headlight out, license plate, these kind of like these really, really, who cares, right? In the big scheme of things.
Yeah.
Whether through development of probable cause, whether through a probable cause, consent, or etc., the vehicle is searched. So the vehicle is searched lawfully. Besides, obviously, we know our viewer. I got a lot of citizens who watch my channel, and they're gonna freak out. What? You can search a car because it's 2 miles per hour? No, but let's say that somebody
Um,
gave consent. Now they find illegal narcotics. Now the driver is actually the citation is written for 37 and a 35, right? Because he wants to put that original reason for the stop in the PC, the probable cause statement,
mm,
and the possession of the controlled substance. Is it an issue if the officer only writes these really minor traffic violations only when he actually has a criminal charge, right? Like the drugs. In other words, if he makes that same stop, the next time, like right after I'm sorry, the previous stop was also for 2 miles per hour over, and he found nothing and let that go with a verbal warning. Can that come up in court as a challenge to the stop and actually be a fruit of the poisonous tree? Hopefully, I said that correctly, Zach, and cogently. So if I haven't, maybe you can fix it. But what do you think?
yeah, I'm following along exactly.
Okay,
And the answer is a resounding, clearly, no question about it, for Fourth Amendment purposes, irrelevant.
right.
The officer's prior history with this particular offense, his subsequent history with it, or his subsequent actions with future violators, it doesn't matter because that's a subjective element. And as we all know very well, the Supreme Court in Wren said the officer's subjective purpose or state of mind is irrelevant as long as there is, in fact, an objective basis for the stop, which is he's going 2 miles over the speed limit
Now,
or whatever the minor infraction was.
sure. Now, Ren is a 1996 case, WHREN. And, that is a case where there was proof of a pretext. You think there's proof of a pretext here, Zach?
Yeah, I think there's yeah, I think
I
it's
mean, look,
pretty
I can
obvious.
tell
This
you,
was
if there's a town in Ohio that is so focused on speed enforcement that they're stopping people 2 miles per hour over, there's gonna be riots in the street. You know what I mean? So it's
absolutely.
really it's not people on the up and up like me and you, right? It's probably somebody who went to a known drug house for 2 minutes. They can't stop him just for that, so they think to themselves, "Hey, he happens to be going 2 miles per hour over the speed limit." Now that's a pretext stop, and as Zach said, the Supreme Court made it very clear that it's not what you carry, what you have in your brain, as long as it's not racial profiling. Sometimes people think pretext means racial profiling. No, they're two different things. Pretext is really criminal, kind of criminal profile or criminal hunches, but it's not because of their race, ethnicity, national origin, religion, and so forth. Okay, so that's two different things. Racial profiling is highly illegal and unconstitutional in America, and always has been. So, um, anyway, besides the point. So the cop stops him, and then we just go from there. You don't, yeah. Is it going to come up, Zach? Sure. You're going to get maybe,
Sure.
if I
Yeah.
do some discovery, isn't it? Why didn't you stop? Cite those people for two over because I chose not to. Could that be the answer?
Absolutely. That's a sufficient answer, and I would just leave it right there. We don't, our officer is tempted to get sucked down to that rabbit
Yeah.
hole of an argument, and just like you said, I chose not to
Yeah.
in the
Well,
prior case.
they were nicer to me. I don't even care. It's because I chose not to, because I have discretion and I chose not to.
Yeah.
Now, since we're on the topic, my friend, a couple observations. Number one is this probably, these de minimis, these so minimal violations. I mean, they 37 and a 35 is kind of rare because most people are going a little faster than that. But as a former trooper, I've always been concerned with my troops as a sergeant. I was always concerned, like, hey, guys, don't stop people for 2 miles per hour over. And the reason I said this is because I knew, based on my radar training, that my radar was only certified for plus or minus 2 miles per hour. So if I went to court and I said, hey, I got him at 37 and a 35, I could also be saying they were doing 35 and a 35 because I don't know what that margin of error is. Do you think that is at least an argument that maybe some defense attorneys would bring up if we actually really had a 37 and a 35 case?
Absolutely, and it's I think it's most relevant in the proof beyond a reasonable doubt to convict to actually find
Oh,
him for
right.
this. But you're right, yeah. We never know we'll never know exactly how fast he was going because the radar can't be, it doesn't have to be that accurate. Yeah, these really close ones,
Yeah.
if we're just citing this guy for 2 miles over and hoping we're going to get a conviction on that for the speeding, yeah, there's there's a lot of reasonable doubt lingering around there.
Now the other thing is that a lot of states, when they change their traffic code to civil violations, they also lowered the burden of proof down to preponderance of the evidence.
Yeah,
So
but
actually now, because PC could be less than preponderance of evidence, but now, you're not, if it's a misdemeanor, you're not gonna. I don't think you're gonna win it 2 miles per hour. I think you can. That's reasonable doubt. But just kind of interesting, right?
mhm.
But if it's a civil and it's preponderance of evidence, maybe you win that case. But I guess here's the point. First of all, very rarely are people only doing 2 hours. If that's all you got in this guy, he's probably committing.
Well, you haven't followed him long
You
enough, or
have
you're
not
not paying
followed him long
attention.
enough, right? Just get close on his
Right.
bumper so you kind of encourage him to go a little faster. And then, so I got to laugh when I say stuff like that because there's, some people out there that are like, oh, he's teaching you guys how to violate people's rights. And the other thing is, more often it's like the one headlight and so forth. All right.
Mhm.
I think that's about it on that one. Anything else to add?
Can I throw out a case just to kind of support our position? It's a Louisiana case, but it's where the court says the fact the officer did not write a ticket is irrelevant to the constitutionality of the stop.
Yes, I love that.
And it's decided under the Fourth Amendment. So yeah, it's a Louisiana Court of Appeals,
Hmm.
2014, State versus Williams is the case. If you're just looking for a case to support what we said, yeah, this question came from Ohio, but this is a pretty straightforward Fourth Amendment
Yeah, absolutely. And I'm glad
principle.
you actually said that because the officer then threw out here. He says, "Look, also I've heard right that there was a drug interdiction case in Ohio. He doesn't give a name because he doesn't know the name, but this was like passed down from generation to generation, where the court said that because the trooper had never written a citation for that violation before, meaning very minor violation, whatever it was, the court threw it out. And he says, "Is this an old wives' tale?" Or is this something legit? No, it's an old wives' tale. Ohio, right, is a Fourth Amendment state. It complies with the Fourth
Right.
Amendment, almost fully, and that's a wives' tale. That could be a judge that doesn't like it, that has absolute immunity and can just throw things out without getting any repercussion, unless you appeal it, right? But at the end
And
of the
maybe the
day,
state didn't appeal that. Yeah, maybe the state
yeah,
chose not to. Maybe it did happen one time in a
correct.
trial
At a
somewhere in
trial level,
Ohio.
it ain't gonna happen at
Yeah, trial level.
it ain't gonna happen.
Right.
Now,
Exactly.
before I end off, do you know that this there are actually some states that restrict pretext stops?
I do. I know Washington is one of them, and
Washington,
correct me if I'm wrong, is New Mexico another one as well?
correct.
Okay.
I'm not
I
aware
don't
of
know
any
of any
others.
other ones.
No,
Am
I
I
don't.
missing anything else?
No, not to my knowledge.
Yeah.
All right. So there you go, guys. So I hope you found this information useful. We're really taking our time here, to educate you guys, to keep you sharp, your legal survival. If you like what Zach and I are doing, you know what to do. Like, subscribe, share with your friends. Until next time, my friends. You guys stay safe.
See you next time.